Dictation will start in 5 seconds. Get ready, start. This appeal assails the judgment and order delivered by the Division Bench of the High Court of Judicature at Bombay in Criminal Appeal number 46 of 2005, thereby dismissing the appeal of the appellant and maintaining the conviction and sentence of the appellant as passed by the Additional Sessions Judge Islampur in Sessions Case number 39 of 2003 for offence punishable under section 302 of the Indian Penal Code for short IPC signature not verified. Para. The prosecution case in brief as could be gathered from the material placed on record is as under. Deceased Jayashree was married to the accused prior to about 8 or 9 years from the date of the incident. They were blessed with two issues. PW3 Anandibai is the mother of deceased. PW5 Ramchandra Chintappa is the brother of the appellant who was residing separately in different parts of the same house. It is the case of the prosecution that the appellant was addicted to liquor and used to abuse and beat the deceased, forcing her to get money from her mother. On the fateful night of 23rd March 2003, the accused and deceased went to sleep in their house. At the dawn of 24th March 2003, PW5 gave a call to the appellant so that they could go to their field for harvesting jawar crop. The accused opened the door and expressed his inability to accompany him to the field, stating that Jayashree had committed suicide by hanging. PW4 Ramchandra Shankar resides near the house of the appellant as well as PW5. PW5 informed PW4 about the incident. PW5 went to the village Panumar to inform the mother of deceased and other relatives about the incident. PW5 went to Kokrat police station and gave information about death of the deceased. On the basis of information received from PW5 initially, ad number 13/2003 came to be registered. Subsequently, crime came to be registered for the offence punishable under section 302 IPC. As per the advance death certificate, the probable cause of death was asphyxia due to strangulation. The charge sheet came to be filed before the jurisdictional magistrate first class. Para. The case was committed to the learned sessions judge. Charge was framed for the offence punishable under section 302 IPC. The appellant pleaded not guilty and claimed to be tried. At the conclusion of the trial, the learned trial judge convicted the accused for the offence punishable under section 302 IPC and sentenced him to imprisonment for life. Being aggrieved thereby, the appellant preferred an appeal before the High Court, which came to be dismissed. Hence, the present appeal. Para. We have heard Sri M. Kamaruddin, learned amicus curiae, appearing on behalf of the appellant, and Sri Sachin Patil, learned counsel appearing on behalf of the state. Para. Sri Kamaruddin, learned counsel for the appellant, submitted that the case rests entirely on the circumstantial evidence. He submitted that unless and until the prosecution proves its case beyond all reasonable doubt, conviction in a case of circumstantial evidence would not be warranted. The learned counsel submitted that merely on the basis of suspicion, conviction would not be sustainable. He relies in this respect on the judgment of this court in the case of G. Parasnath versus State of Karnataka 2010 SCC 593. Para. The learned counsel submitted that in the present case the prosecution has not been in a position to establish that the death of the deceased was homicidal. He submitted that if the evidence of PW6 Dr. Kishore Patki is considered, it would reveal that the evidence is inconsistent with the theory of homicidal death. In this respect, the learned counsel relies on the judgment of this court in the case of Swarupa Elias Dhupada Sorabba versus State of Karnataka 2019-16 SCC 269. Stop.